Okay, we're live.
Mm.
Okay, so we are gathered here today to talk about Sarah Grace Pat or not Sarah Grace Patrick. we are
The
gathered
best
here
thing ever.
to talk about Kelsey Fitzsimmons. So, sorry, my dog's deciding she wants to play with her toy right now. Of course. Um, the reason why I can hear myself echoing a little bit on.
I can't hear it a little, or I can't hear it at all.
Um, maybe it'll stop because it's not that bad. Um, so the reason why I wanted to talk to you about this is because I know you have kids and stuff, and I think this case has a lot to do with the stigmatization of postpartum depression. I don't know if you ever experienced any of that.
Sure did.
Yeah, same. It's
Sure did.
been
And
a.
I'm very familiar also with postpartum psychosis.
Mm,
Not personally, but I've actually looked a lot into that because I found that fascinating.
me
So
too.
yeah, yeah.
Yeah, so what I was wanting to share with you, I was going to read you this article about what happened. So it started off by there was this girl that was a police officer, and she was like pretty young police officer up in Massachusetts, and that's why like a lot of the Karen Reed crowd got into this case or are getting into this case, and so also I'm just like just found out about this yesterday from Defense Diary, so I haven't been following this or anything. But whenever I heard it, I was just like shocked and immediately had to reach
I'm
out to you so I
excited.
could spill all the tea.
And for the
So,
record, for anybody that watches this, I've never heard of this case
oh
until
yes,
yesterday.
yes,
Yeah, like I have no idea.
yeah. I asked her if she'd ever heard of it, and she said no. So I was like, oh, I got to get your reaction to this because whenever I
Yeah,
was listening to it in the car, listening to Defense Diaries cover this, of course they cover like the more they're lawyers, so they covered the legal aspect, and we're just kind of like moms, just covering, the woman aspect or the human aspect of this.
yeah.
So this lady is a police officer up there, and she and her I forgot if they're I think they were fiance. I don't think they were married yet, but um, so they were together and they had a baby, and they were involved in like a domestic dispute, and the cops were not called during this domestic dispute, but afterwards the dad of the baby went and got a temporary restraining order, which to get a temporary restraining order you don't really have to have any proof. It's an ex parte hearing, meaning that it's done without the other party. It's like an emergent thing, and then
Yeah,
then they set a court date to where you get like an actual um, order of protection or whatever.
yeah.
So really, all you need are allegations to get that. You just say kind of your side of what happened, and usually there's a police report involved. But in this case, they didn't call the police. So what had happened? She was getting served with her restraining order um, when she was postpartum. They just released her back to work. She was having some mental health postpartum issues, like postpartum depression issues, and they had just released her back to work. And when this happened, and I think there was alcohol involved in the dispute, and I think maybe she had been struggling. Not, I don't know if she had been struggling with alcohol, but there are rumors that she had maybe a problem with alcohol at some
Okay.
point, and then maybe was exacerbated by the
Postpartum.
yep, by the postpartum issues. This article, whenever whenever she was getting served with the order of protection, there was a confrontation that happened between the police officer serving and her. And this is in Andover, Massachusetts. So I'll read this
Can I ask you
article.
a question really quickly,
Mm-hmm.
just so I have it clarity?
Yep.
So she is a police officer.
Yes, she's a police officer. Her boyfriend or fiance is a firefighter, EMT, and she's getting served by one of her former colleagues right now with
Oh,
the order of
oh,
protection.
okay. One of her former colleagues. Okay, okay, great. I'm here. I got it.
So what had happened was whenever the former colleague came to serve her, she was trying to attempt suicide. She pulled a gun out and was trying to kill herself. Because the order of protection means that they were gonna take her baby because the baby was involved. Like, they included the baby in the temporary restraining order, and they were gonna take her gun and they were gonna take her job. Whenever, like, that's what that means. Whenever you're a police officer and you get served with the order of protection, is they take your gun and then they suspend you, I think. So
yeah. Sorry, one more question. Mm-hmm. So I understand there was a situation with a colleague, but just go ahead. You're probably going to answer.
Yeah, this will probably explain it. An armed confrontation between an on and off-duty police officer in North Andover, Massachusetts, left an off-duty officer wounded Monday night, officials say. The shooting took place as an officer served a court order at the residence of an off-duty officer about 6:30 p.m. According to the Essex County District Attorney Paul Tacker and Northover Police Chief Charles Gray, an off-duty officer fired during the confrontation, and the off-duty officer was rushed. Wait, I'm sorry, I misspoke. An on-duty officer, so the server fired during the confrontation, and the off-duty officer was rushed to Boston Police Hospital. So this lady was shot, basically. She pulled the gun out to try to kill herself and instead got shot by the police officer. The officials didn't release any information, including identities of the officers involved, the name, or anything like that. Okay, so that's basically the beginning of it. So she has to go to the hospital because she got shot. I mean, it was an officer involved shooting, and so she releases a statement, and so this Attorney Bradle, he was involved in Karen Reed somehow. I don't know. I think he's with Turtle Boy maybe, but he's up there somehow. And it says, it is time to end the PR war on, and this is a statement from Kelsey Fitzsimmons through her attorney.
Okay, and Kelsey Fitzsimmons is the off-duty officer, right?
That had
the one that had the baby, postpartum. She was going to kill herself.
Yes, and instead she got shot by the person delivering the restraining order against her.
Okay.
So she says, it is time to end the PR war on North Andover police officer Kelly Fitzsimmons. As Kelsey recovers from her life-threatening injuries, she cannot sit idle any longer. In our first, and this is her only baby too. Like, I don't, like, not that it matters, but I just feel like, your baby is your everything.
Yeah, especially when you're a new mom. You're already flailing around, like, trying to understand what's happening to your body, what's happening with your mind, how to make sure to be the best mom ever, second guessing the shit out of yourself, and also taking care of your baby. And then you have postpartum on top of it.
And then also being a police officer and having that stigma against anything mental health related at all.
Yep. Yeah, for sure.
So as we stated, we would have preferred to address the facts of the matter in court, but Kelsey believes it is imperative that she has been battered with leaks from negative and false allegation, and she speaks now to set the record. And here's what she says. My name is Kelsey Fitzsimmons, and as I recover in my hospital bed, I am ready to speak about the incident that took place June 30th, 2025. This is the incident. In my home where I almost lost my life. I was diagnosed with postpartum depression March of 2025, approximately 3 weeks after giving birth to my beautiful baby boy. I have been actively in treatment since the day of my diagnosis, and was eager to heal and feel like myself again. Unfortunately, healing a sickness does not happen overnight. However, what can happen overnight is my life turning upside down into something so horrible my mind wouldn't even be able to imagine if it were my current reality. Someone who I thought understood my diagnosis, loved me in sickness and in health, so I guess they were married, and was in my corner for the journey of my active treatment to get better, turned their back on me. Said person is now legally bullying me and to get what they want, slandering my character and using my diagnosis against me to make it seem like I am a monster. There are more false allegations than I can even comment on. The deep love I have for my baby boy sustains me and keeps me strong. I have spent more than a night away from him. I haven't spent more than a night away from him since I delivered him, and I adore every moment I spend with him. He's my best friend, my miracle, my little man, my sweet boy, and importantly, a giant piece of my heart. Right now, that piece of my heart is missing when I need it the most. I am 5 months postpartum without my baby boy who needs me as much as I need him. I would never put that angel of a child in harm's way. My job is his mama to protect him. But yes, just more stuff about. Wait, I don't want to miss anything, but
it's a long ass statement.
Yeah, it is a long ass statement.
I mean, I understand why it might be long.
Yeah. On June 30th of 2025, I received a phone call from my fiance to meet him at the park to go for a walk with our baby boy together. After almost 3 hours of waiting for him to go to the park with no communication from him, I went home very confused as he never showed up. And I really think this case is going to blow up. So, I mean, it's...
I can already sense a vibe right there that I could talk for hours on.
Yeah.
So,
and just wait. More and more and more and more.
I'm making notes. Yeah. I can already sense that.
An hour later, I was sitting on my couch feeding my baby boy when I got a knock on my front door. Very confused to see 3 of my colleagues. I open my door and I am told the following. Your fiance has filed a restraining order against you. He will be taking your son away with no contact allowed. Your firearms license that was just returned is gone again. And oh yeah, that career you worked so hard for and love that you were just cleared to return on, that will be taken away too. Following this interaction, I packed bags containing baby food, clothes, diapers, toys, etc. for my son to be taken from me. I passed my son off to a fellow officer and I went into my bedroom. In that horrible moment, I didn't want to live after my whole world was turned upside down in a matter of a 10-second conversation due to someone alleging horrible, untrue things. We have a broken legal system where someone can walk into a courthouse, write anything that self-serves them on affidavit, and as a result, a brand new mother suffering from postpartum depression gets her baby taken away. We are calling for legislator and governor to reform this abomination. The courts are not equipped for proper on-the-spot decision-making. As a police officer, I am trained to know what to do if I encounter a suicidal individual who is only displaying threats to themselves. I certainly was not trained to shoot a suicidal person in the chest, but here I am today, 2 surgeries later, bedridden, trying really hard to heal from these significant injuries. I am facing felony charges for a half-hearted attempt to take my own life. Let me say that again. I am in trouble, and I have a gunshot wound to my chest because in that awful, isolated moment, I no longer had a will to live. I never pointed my firearm at the officer. That officer was not just a colleague, he was my friend. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing this together. We entered a home and walked into something no human should ever have to see. A murder suicide scene with a mother and infant. As a rookie police officer, this was devastating to me. At the time, I was 20 weeks pregnant. That just gives me chills because I could just imagine the hormones just being released in this poor girl, at that.
As a mom, even listening to her statement right now, I can feel my mom alerts and everything going off, emotionally. I can feel it all going off.
Yeah.
So her being 20 weeks pregnant in a situation like that, I can't even imagine.
Yeah. The officer that shot me experienced this call with me. To this day, his support during that time, that hard time, is something I am still grateful for, regardless of the recent incident that occurred. This traumatic suicide call was the catalyst for my mental health complications. As a police officer myself, I would never even think to intentionally hurt another officer. I see everyone in uniform as my brothers and sisters. Especially would never hurt my friend who is a loving wife and children. I would never. My firearm was never pointed in any direction other than my temple. When I pulled the trigger, my gun did not fire. However, I immediately got shot in the chest by my colleague and friend. I am extremely grateful for 2 things: God, protected me from taking my own life, and protected me from millimeters from dying from a gunshot wound to my chest. I will survive and thrive. I, I, na- I know I need to be on this earth for many reasons, for my son and God. Um, so I would like to, and this is the end of it. I would also like to note from the very beginning, I acknowledged my diagnosis of postpartum depression and immediately sought help from medical professionals. I was failed by so many. The narrative that has been released by NAPD is vague and non-committal for a reason. If body cameras were worn by my department, I would not be in this position where I'm wrongfully accused of pointing my gun at this officer. I know the truth will prevail. So, thoughts?
Okay, well, I literally just wrote down no fucking body cam. Are you shitting me?
In this day and age? Yeah.
Admission of like, hey, we're a police department that's trying to cover shit up. Like, why are there? Okay, well, I'm gonna remove that. I want to know, is there any information on how long the coworker was on the job? Like, how many years? Was it well, it couldn't have been too much of a rookie because
I think she was the rookie. She was the one.
She was the rookie. Oh,
yeah,
so it had to be more of an experienced officer then.
I would hope so. Yeah.
So then there's no like, hey, he or she. Do we know that? If it was
it was a he. It was a he.
Yeah. Okay. So there's no saying, oh, he's inexperienced. He panicked. Even with the training and everything, he panicked. I understand that. Even though obviously I feel like police should, and I think do get the training, but you never really know until you're in a situation like that. But that's not an excuse here, because it's obviously not a rookie cop. So there's nothing to say about that. Let me see if there was anything else. There was nothing else that I could really, except I was expecting this case to go in the, like, she had the gun to her temple, and she, like, and when she went to fire, she was shot in, like, the leg. So when you said shot in the chest, I freaked out. What? So, I don't want you to kill yourself, so I'm going to kill you for you.
Yeah.
Like, that's basically assisted suicide at that point. Like, what the fuck are you doing?
Yeah, like suicide by cop.
Yeah, like, what? And no body cams. So he can say, oh, she pointed her weapon at me. But it's like, he catch a lot of shit for this. Because if you had body cams, then it wouldn't be not. Yeah, that's it.
You keep freezing a little bit too.
Sorry.
No, it's okay. So they brought charges to the grand jury on felony murder, or I forgot exactly what the charges were, but there were like 3 big charges. Not murder, attempted murder. For
on her?
Yes.
No.
Yes. But the grand jury did not indict on the top one, like the man, I forgot to get this part ready, but they did not indict on the most egregious one, but they did indict on the other 2, like I forgot exactly what they were, but so she's still going to court for this, and she's still, she's in jail and trying to get out on bond. Yes.
No.
But wait. So she got out. And she got bonded out, and
Sorry, 1 second. I'm sorry. It's my kid. One second.
No, this is my dog is too. So you're good. 1 second.
I'm so sorry. My 4-year-old.
Oh, you're good. Matt came in here and was fixing all my tech stuff too, so it's all good.
Okay, cool.
Okay, so and also I found what I was wanting to tell you. So, she had the diagnosis of postpartum. When asked for comment on the statement, a representative for the Essex County District Attorney said the facts are in support of the charges that were issued out of Lawrence District Court will be detailed in the arraignment in open court. She remains hospitalized. Where did I just see that? I just saw the charges. Sorry, I came in here and then Matt was
You're fine.
clicking around on stuff.
But next time we go live, I'm gonna have to just have a babysitter or have my husband.
It's all good. There's literally 2 people watching this. It'll be fine.
Okay.
Yeah, I just wanted to read off her exact charges, but I don't know what I did with them. But yeah, she had the murder charge, or the attempted murder charge, but then they knocked that one down. But so she goes to court, and she gets released on bond, and then under the order that she takes this alcohol testing, and the alcohol testing is a breath device that she has to blow in. So it's called SCRAM testing, and also she had to have a surgery, and she was on an ankle monitor, and they wouldn't take the ankle monitor off for her to have surgery. She had to cancel her
during
surgery.
the surgery.
Yes, they wouldn't do it, even though the probation officer said that that was they were willing to do that.
So then who said no? Who was the person that was
the judge? And you wait till you hear this court hearing. So I guess we'll play this court hearing. I'm gonna play it and I'll mute you and let me know if you can hear it, okay? Because I think I can play it. I mean, I don't know.
If not, I can play it on my phone.
But I don't know if I'll need to stop. Is what I was just thinking. But maybe because it's 26 minutes. I'll start playing it and let me know if you can hear it, or you can start playing it like on your playing like through my YouTube video on the phone, and that way you can tell if I pause it.
Mine will be like a little bit delayed, maybe like 10 seconds or whatever, but yeah.
Okay.
311 before the court in the defendant's motion. If the parties would please identify themselves for the record. Good afternoon, James Gubachowski on behalf of the Commonwealth.
Good afternoon. Good afternoon, Marion Moriarty for the Commonwealth. Good afternoon. Good afternoon, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons. Good afternoon.
Hello, Your Honor. Timothy Brado for Kelsey Fitzsimmons. She's present in the courtroom today for the record to my left.
Good afternoon, Mr. Good afternoon, everybody in the courtroom.
Thank you.
So I received the defendant's emergency motion for immediate release from the SCRAM order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that,
Just so you know, SCRAM testing is the alcohol testing. It's the blow testing.
causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them, but she has about 4 hours of pain and dizziness afterwards. And you know, I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, you know, we're not trying to get any sort of advantage over anything. We just want her to not, A, to not be in pain for hours after these tests, and B, you know, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, you know, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, you know, I think that says it all. That's someone that has no bias or interest, and, you know, probation enforces court orders, and that's that. And he is telling the court this is a problem. And, you know, this is something that should be addressed. And
okay.
So I see this as a simple adjustment of terms.
I don't see it that way. Just so you understand where I'm coming from, I don't see it that way.
Okay, can I?
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just the means of determining that's the adjustment. That's what I mean when I say this is an adjustment. That,
well, a SCRAM is what was ordered. Now, was she unable, when you said that there was a knock on the door, explain that to me.
No, Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door because of these tests. It's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay.
And that, you know, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just, that's something that I just want to ask the court to adjust somehow.
Sorry.
Okay.
No, you're good.
Because I'm 10 seconds behind. I feel like my reaction might not be like 100% in line with what is being heard. So I just want to, you know, I'm listening intently. I just wanted to make sure, like, it might not line up with the video, but I'm already like, what?
Yeah. So I think it's like so crazy how she's got this attitude where it's like, and this case just started, you know, it's but just it's fucking wild.
I do want to say one thing. I always look at judges, and maybe this isn't fair of me, but I do. So I always look at judges. You know, judges, they have to have experience in, as far as I'm aware, they have to have experience in prosecution and defense, right?
I don't think so. Sure. I think,
no,
but most of them do. Most of them do.
Okay,
but
I feel like that makes the most fair judge. But
yes.
I can tell a prosecutor judge really quickly, and I'm not going to say that that's a fact because I don't know. I haven't looked into her, but
and I think this judge used to be a defense attorney.
No way.
Yes.
A shit one?
Yeah. I mean, I don't know. I don't know.
God.
Yeah.
All right. I mean, I'll wait. I'll hold my judgment until then. I'm picking up.
Okay.
Somebody. Okay. All right. I'm going to mute myself again.
Okay. So you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing?
this part, she is asking the prosecution to object. She is asking the prosecution.
Oh, I haven't
to
gotten
object.
to that point.
I'm so sorry.
I
I'm so
wish.
sorry.
No, it's fine. It's fine. It's fine. It's fine. This is what sucks. Is like I wish we could watch it like at the same exact time.
Yeah, well, I need to do a deep dive and figure this out. But I'm just gonna
we'll
rewind it just a few seconds and replay it.
Okay.
Environment, and just that's something that I just want to ask the court to adjust somehow.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay. So you have a burden. It's your motion. What do you want to do?
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
I don't know if you're there yet, but she said the court gives that 0 weight, and the person that wrote that email is in that court right now and willing to testify, making it not hearsay, and also hearsay only matters in a trial, not in pre-trial hearings.
Right. I have never, ever heard a judge act. I was literally sitting here being like, what is happening with her that day? Like, why is she acting like that?
And apparently there's all kinds of there's like a bracelet that can measure the alcohol in your perspiration that you can get. There's blood tests you can get. There's like all these different things. And it's just wild.
And she keeps on bringing up for 3 days, as if 3 days is so fucking long. Like, oh, it's been in effect for so fucking long. Like, you're talking like 5 months. Like, it's been 3 days, bro.
And this wasn't really, I mean, not that I can tell. I haven't seen alcohol being related to any of these issues. Like, I understand the alcohol. I think she did have an alcohol issue, but I don't think alcohol really had anything to do with.
Right, like, is it even in the police reports that she was intoxicated?
There was no police reports because they never called because he all he did was go to go get a restraining order. It was just his word.
Oh, so no police reports, no fucking body cam. That's cool. And then the judge in the case is gonna treat them like this. They just basically they just want to do whatever the fuck they want. That with no accountability whatsoever. That's literally what they want to do.
Massachusetts seems so bad. I know. Whenever I was listening to this, I was like, oh, I gotta tell her. Okay. We're only 4 minutes through.
God.
Okay, I'll let it go. Sorry.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happens. I think that's, the more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother. You have an affidavit from Ms. Fitzsimmons. And the other day we were here, I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I just would just argue that it's somewhat self-evident as well. Thank you. It's somewhat self-evident as well. And that, she's having great difficulty here. It's been observed by probation. It's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant.
So I want to hear about the one she had difficulty with. When was that?
Except one moment. Well, so that's what I was saying. I don't want to conflate passing with not having difficulty. She has difficulty with every single test, and so she passes them in great pain. So she's had difficulty in every single one. Equated, it's in the affidavit. So she has difficulty on every single one. So that's different than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to, was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes,
And she was unable to perform it?
correct.
Okay, was she unable to perform it?
No.
What happened?
No. So this, since she's been released,
Yes, where in office? The
Raise your right hand,
probation
please.
officer.
Do you solemnly swear you will make true answers to such questions that may be put to you by the court or upon its directions to help you
I
God?
do. Or if I could just pass this up, this is
Sure.
information pertaining to all of our students.
And is that being submitted, Attorney Braille, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Your Honor.
Okay,
It
so
just says that she passed the test, which is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes it or
Okay,
not.
so there's one Officer January that says incomplete at 9/10/25 at 3:09 p.m. Is that right?
That's correct.
So what does that mean?
Yeah. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially she answers the alert and attempts to take the test but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries. And then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9/10/25 at 3:09 p.m.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9/10/25 at 9:30 a.m.
okay, so you're looking, I'm referring to the second document, it's multiple pages.
I think if you just go up instead of the one above it, the
Okay.
incomplete is the.
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
Again, at 3 o'clock.
but she
The test is initially incomplete.
at 3:09 and then it's complete at 4:21.
4:20, 4:21.
So there were
It gets
two
less
times that
boring
she had
in
an
a minute.
incomplete test. Is that
Yes,
correct?
incomplete.
And what's the
Hold
procedure
on,
in the
I didn't hear
probation
you. What?
department when somebody who has a condition of release?
What'd you say?
I was just saying it gets less boring in a minute.
Oh, no, I don't find this boring. You're good.
I don't either, but I'm just.
Maybe it's, yeah.
To have SCRAM and to pass a SCRAM test in a very serious case if they're incomplete. I have two incomplete tests and I was not made aware of either one of them.
So my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, actually doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, like genuine pain. So I know.
Any objection to any of the terms used by?
I don't know if you're there yet, but this is the probation officer speaking.
Hold on. What?
This is the probation officer speaking. I just wanted to let you know that.
Okay, that I thought I kind of gathered that, but yeah, okay. That I'm glad you clarified that.
Probation officer, okay.
So we have all that. Doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, like genuine pain. So I know.
Any objection to any of the terms used by the probation officer? Okay.
So we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance. And she, with her obstacles.
I'm getting confused. What do you mean compliant? As far as when she was initially,
that's compliant with SCRAM testing. She was ordered.
When she initially was started to be monitored by SCRAM and you went through the preparations. Is that right?
That's correct.
Okay. So when something is incomplete, do you typically bring it to the attention of the court?
No, that's not what we do. So if something is incomplete, as in this case, at 3 on September 9th at 3:09, we have an incomplete test, which is a scheduling test.
Mm-hmm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance. If someone missed the test because they were down in the basement doing laundry, and then came up and realized that they had a test, took an on-demand test 20 minutes later, and passed the test, which means there's no alcohol in the system. We don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's
that's your position as non-compliant. It's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying is those situations you described is what you deem as appropriate to bring before the court.
So I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation from our end, because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and that's not, we don't deem that non-compliance. We never have, and we never would in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so the schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows when she's going to be tested?
With Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule, because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court. None of that was ordered. She was ordered.
It was random screens. Excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule, as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I can clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with SCRAM testing, we always default to creating this testing schedule.
Okay.
And up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. And the test to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case, and it's done on every case.
Okay. Attorney Bradle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard Your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No,
Bradle?
my objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, that says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that the SCRAM condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
Well,
Sponte?
if the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's for the motion to vacate the SCRAM device. So do you have anything else to submit, Attorney Bradle?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is. In light of the court releasing the defendant, that testing be done.
Okay. Attorney Bradle, first of all, I do have a question. So
it sounds like the prosecution is like saying, I don't care as long as the testing's done. As long as there's testing, I don't even care.
Ms. Fitzsimmons is able to do the SCRAM, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
That depends on whether the court is willing to tolerate that the material represented in the
The court is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to SCRAM. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours. I
understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all, so I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for lack of alcohol, that's completely fine with the defense, but just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay.
But
it is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the SCRAM as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes. I'll break.
Court, hold on. Goes back in session,
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws, Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the SCRAM installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by SCRAM, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by SCRAM. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will follow.
May I address the court?
That's the court's order. Thank you.
All right, Your Honor, I object. I ask you to stay your order pending the SJC.
So she's going back to jail. She went back to jail. She's in jail right now.
When was that?
Just I think a couple days ago. Hang on, sent back to jail. Her next hearing is 9/23. And also, I have her donations for her legal stuff in my description.
Okay, so oh my god,
Yeah.
I have a lot of notes.
Yeah.
One, I was right in the middle of, so I'm not even like in order, but she quoted the defense attorney and said, I understand your position is this is cruel and unusual punishment, but she's the one who fucking said that. Yes, she did ask, is that your position? Is that what your position with the court? Yes, she did ask that, but she inserted the living fuck out of that and then quoted him on it when he did not say that. He said, yeah, it's pretty much a form of torture when someone's shot in the fucking chest. Sorry. That really made me nervous. I have a lot of notes.
Isn't it more infuriating that, and to add on top of it, they wouldn't let her get that surgery. They wouldn't take that thing off of her to let her have surgery.
Yeah.
So there was other options available that she did not consider. And then, so just recently, there was a filing where, hold your pants, because this is going to piss you off too.
Oh no.
Yeah, where her husband filed to sell the house for child support, even though she's not been convicted and she's not had her child taken away from her legally. She's not had any of this happen. He filed a motion. I forgot exactly what the motion was, but to sell her house and have the equity in it go towards child support that has not been ordered for yet. There's no order for child support.
Considering that, or he just filed it?
He what?
Has he just filed it, or is the court like actually considering it? Like, or is that
he just filed it. It's like what he is wanting is like a stop, so she can't sell it for her legal fund.
So he's gonna use the excuse of, oh, I'm gonna need. So it's basically he's anticipating that he's gonna need it. Which, look, I will say, I don't know his side of the story. So whatever. However, what in the flying fuck happened to due process? What the hell?
And this girl was failed on so many levels of the mental health help that she needed. You know, like his statement against her was she hit him multiple times with a closed fist. I forgot exactly what all, but I mean, it wasn't good, you know, but it didn't have anything to do with the baby. And
And I need proof of that as well.
yeah,
You're gonna have to
there,
show me
and
that.
there's no proof at all. No proof at all.
Show me a picture of some marks. I mean, that's normal. You have to provide something. Like, I'm not going to blindly believe someone is, and I'm all for the fact that men are victims too, and like they are really underrepresented. Like, I feel that 100%. However, you have to fucking provide something. It can't just be your word. Like, oh my God, this is actually making me mad.
Yeah.
I'm actually mad.
Yeah. Yeah.
Do you want me to go through my notes really quickly?
Sure. Yeah. I think that's the end of it. That's
Okay. Yeah, because I'm just gonna
caught up.
Yeah. You see this?
Yeah.
You see this? My chicken scratch. Yeah, there's a lot. Okay. The way that the judge was so dismissive of fucking, and it's in caps, the fucking probation officer. Why was she so dismissive of him? And that's a probation officer. That's his job. And like, he's usually the guy being like, no, like, we have to be really strict, you know? And he's saying, I'm seeing actual pain. I'm seeing physical issues going on over this test. They're just asking, can we find a different test?
And they
exist.
And she just shut him the fuck up. She said, why are you talking? You know, basically, why are you talking right now? You're talking out of turn, basically. Yeah. And what Defense Diaries was saying was that, you know, usually these probation officers and judges work like in tandem. They're co-workers. They see each other every day, you know, and why and it's
that
so rare
leads to my next question. So I want to know, does she have some sort of negative experience with the officer and or this defense attorney? Because I'm sensing a vibe of she has to have some sort of, like, she thinks that they're quacks for her to treat them like that and speak to them that way, which I understand. Like, judges sometimes can get like stern, which I think they should, but this was like gross. It was disgusting.
Yeah, it was.
Okay, I did that one. Let me see. Oh, I don't even know what I was writing there. I said, what do you mean in compliance? I don't even remember what that was about.
Well, and yeah, that was kind of about, like, he was explaining to her, and she was like wondering why she wasn't informed that she was out of compliance, and he's like, no, she's in compliance. Like, if she misses
right,
the
okay,
test,
then that's what my note was about. It was like, she was being like, oh, so she's out of compliance. Like, no, that's not what we're here to say. Like, to sit and fucking listen.
Yeah. Like,
shut your damn mouth and listen, and don't have any sort of bias in the situation. Just listen and be a judge, you know? Like, oh, it drives me nuts.
And especially she's a woman, you know, like, because this all started from postpartum, you know. You'd think that, you know, she would have a little grace.
Yeah. And
now this lady is sitting in jail without her baby, you know, and
even longer than she already sat. Like, that's
and
with no proof, with absolute not a speck of evidence. Come on, if you showed me evidence of it, and like, okay, yes, the baby was in danger. Yes, her fiance was in danger. Yes, she was doing this crazy shit. She was hitting him, whatever. No problem. Like, okay, lock her ass up. No issue. We're not seeing any of that, and your county has look it up and issue the what's it called, the Freedom of Information like request for the, you know, like, we can't even do that because it doesn't exist. So we're literally just trusting this one person who, I don't know, I'm not going to speak on it that much because there are two sides of every story, or three sides, but his approach to this clearly has not come with any evidence. So I don't know. I have a problem with that.
Yeah. Yeah. There's a lot happening here, and I feel like it's just really sad. The whole thing is really sad. And, you know, if she would have got the mental health help, you know, maybe whenever that traumatic experience happened to her, or if she would have got the mental health help after she had her baby, or if she would have got the mental health help after she tried to commit suicide, or, you know, like, just, yeah.
So after I had my first son, I told my husband, because I experienced postpartum with him. He had gastroschisis, which is his intestines were on the outside of his stomach when, in my womb. So they were like exposed to, you know what I'm saying? It was a whole thing. So I experienced all of that and then postpartum on top of it. And then like his medical stuff, he was in the NICU for 37 days. So when I got pregnant with my second son, I went to my husband and I was like, hey, I'm not going to be in the right state of mind. So if, like, when I have our second son, I need you to be looking out for me and tell me if I need help or recognize signs. If I need, like, I was being a responsible parent by saying, hey, like, if something seems off with me, it probably is. So, like, seek help, whatever. Happening. So, and she was in no condition to postpartum, and that's what, like, and she actually is guilty of some of these things, then that's an issue in and of itself, you know, that like she wasn't receiving the help that she needed, which is a huge fucking issue in our country in general, but that's another conversation entirely.
Yeah, it's wild. This is still playing out, so there'll be some for us.
Oh, this is on my notes. Mm-hmm. The judge said, what evidence do you have that she has broken ribs?
Oh, that's another thing. There was a note from the surgeon that took the bullet out of her that said that she would have trouble breathing for, you know, a certain amount of months or whatnot.
So, sorry, I lost it for a sec. There it is. Okay.
Are you there?
Sorry.
You're good.
Can you hear me?
Yep.
Okay, I lost it for a second. So there was a note on file, like,
I don't know if there was at this time, but there since then has been submitted, and so there was affidavit from the probation officer, her mom, and somebody else that she had pain. But then since then there was a affidavit from the surgeon that operated on her.
So if I were the defense attorney, you know what I would have been like? I'd have been like, you know what? If there had been a fucking police report or a fucking body cam chest, but
You're cutting out real bad.
Shit.
What did you say? No, what?
I was saying if I was the defense attorney in this case, I would tell the judge, like, what do you mean you need proof that she has broken ribs or that she's, like, obviously dealing with medical issues? She was literally shot in the chest. And if you don't have enough proof, maybe look up the police report. Oh, wait, there's not a police report. There's not body cam. So what am I supposed to provide you when the county didn't do what the fuck they're supposed to do? Oh my God, it makes me mad. It makes me so mad.
It is wild.
Oh yeah, that was it. I think that was okay. Yeah.
Yeah, Heidi, there's not much out there about this case. I think it's just kind of all unfolding, and then here recently I've seen the Karen Reed crowd pick it up and start talking about it. And
how do you even gain access? Because I haven't heard anything from the Karen Reed crowd. Like, I don't even know how I would hear from them. Like,
well, I just know from like Twitter, and then the law tubers that were covering it, I have seen, you know, on YouTube.
Okay.
So that's what I've been seeing.
Because I would love to see what people are saying about this. I guess I could look it up because I'm brand new to this.
Yeah, Defense Diaries did a 2-part YouTube yesterday. They were having some technical difficulties. So Defense Diaries on YouTube And then the young jerks, which was where I got that from. So that's who's been covering it. And then also Melanie Little. I don't know if you know her from YouTube, but she covered Karen Reed hardcore.
Okay. Can you send me those people?
Yeah.
I know Defense Diaries. I don't watch them as much as you would think I do. I watched a couple videos of theirs and I was like, oh shit, we say the exact same things all the time. So I kind of stopped watching that, but I have that down. But if you could just send me like all of
Yeah, I think it's interesting, and that's what I want my YouTube channel to be about, is these cases that have nuance, and that we can really have a lot to talk about and see all sides, and could play out in many different cases. That's why.
Yeah, because it's not as interesting if you're covering cases that are like very straightforward. Like there's evidence, and that's the thing is like I respect a case like that 100%.
Yeah.
And I'm all about the law and a trial.
Yeah.
So I respect a straightforward case. Sorry.
You're good.
Good prosecution, good defense team, like that. Like no problem. If you convict them, that's fine. But it's these cases where it's like there's something fishy here that really bother me.
Yeah, it'll be interesting to see how this plays out. Next time I hear an update, I'll let you know.
Yeah, definitely let me know, because now that I know, I'm definitely going to be looking this up.
Yeah. All right. Well, thanks for joining. I appreciate
no problem.
it. Yeah, next time.
Anytime you have a case that I have not heard of yet.
Yeah, I just knew this one would be like right up your alley with the, all the different layers. And then that judge, man.
Yeah. There's like true crime cases that I love, but then there are true crime cases. I'm from the South, so there are true crime cases that piss in my grits, and this is one of those.
Yes.
Where it's like, this is definitely pissing in my grits, and I have a problem with it.
Yeah. Whenever I see like an injustice happen, it just. And there's new info about Delphi out today too. Apparently, well, I mean, it's not that big. I am like following Delphi like an insane person, but there's a new filing, and the prosecution still hasn't turned over documents to the defense, and not to the appeal people either. So.
You know what the problem with that case was, and maybe I'm wrong, because I don't know. I didn't really like deep dive on YouTube and TikTok with this case with the Delphi, but I really feel like it wasn't represented very well of like the other side of it, which we could do a whole damn video on that case.
Yeah.
Yes, sir.
Yeah.
So, but yeah, sorry, my kid is about to.
Yeah, no, it's all
about
good.
to ruin all of this. He's about to just take the whole computer down.
It's all good.
Well, thank you for telling me that. I'm excited. Well, I'm not excited. It's terrible, but
yes, it's terrible.
I'm glad
But it's something interesting to